Hi, I'm Jay with Personal Bar Prep, and this is Simplified, our video series designed to simplify rather complicated subjects on the California bar. Today I want to talk about kind of an esoteric subject, but it was on the prior bar in July of 2025, and so I wanted to talk a little bit about the idea of privileges and immunities. Now, privileges and immunities is kind of a difficult concept because the idea of privileges and immunities arise in two different spots in the U.S. Constitution. So first I want to do is explain the difference between the two and then show how they're used or how they were tested in a recent essay. So I want to begin with, first of all, Article 4, Privileges and Immunities, which appears in Section 2, Clause 1 of the United States Constitution. And what it says is the following: the citizens of each state shall be entitled to all privileges and immunities of the citizens in the several states. That is Article 4, Privileges and Immunities. So let's break down what it means. First of all, it speaks of citizens and only citizens, which means in order to have standing to raise a Article 4 Privileges and Immunities problem, you must be a citizen of the United States. That means corporations are not protected by the Article 4 Privileges and Immunities. Organizations are not. Aliens are not. Only individual citizens. If you don't have an individual citizen, there is no protection afforded by the Privileges and Immunities Clause of Article 4. Now, the second part of it that matters is what are the privileges and immunities that they're referring to? What this has been interpreted to mean is that one state cannot deny citizens of other states whatever fundamental rights they provide to citizens of the forum state. In other words, the state of Columbia cannot deny citizens of the state of Franklin the same rights that citizens of the state of Columbia enjoy within the state of Columbia. And so when a citizen of Franklin were to visit the state of Columbia, they would be entitled to all of the same privileges and immunities that are offered to the citizens of Franklin. So, as a result, we need to know what are those privileges and immunities that matter. Well, it's any right that you enjoy in the state. The use of their roads, the use of their police and emergency services, the use of their hospitals, etc. But the most important thing is the right to earn a living. No state can deny a citizen of another state the right to earn a living in the forum state. So California cannot prevent a Nevadan from earning a living in the state of California. Whenever the government passes a law that does that prevents you from making a living in the forum state, and you are a citizen of another state, your privileges and immunities have been affected. And whether or not the law is constitutional will be based upon whether or not it satisfies the intermediate scrutiny test, meaning the law must be substantially related to an important government interest. That's Article 4, Privileges and Immunities. And mind you, it only applies to citizens and it only applies to the states. This is not a limit on federal power. It's a limit on state power. Now, the second place that privileges or the concept of privileges and immunities arises is under the 14th Amendment, Section 1, where it says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, this clause is different. This is now referring to privileges or immunities, where Article 4 was referring to privileges and immunities. So the privileges and immunities clause is under Article 4. The privilege or immunities clause is under the 14th Amendment. Now, let's break that one down and understand what it means. Again, it applies only to citizens, just like Article 4. You must be an individual citizen of a state in order to have standing to raise 14th Amendment privileges or immunities. So now the next question is, what privileges or immunities are we talking about? because these are different than the privileges and immunities in Article 4. And what we're saying under the 14th Amendment privileges or immunities is that no state can deny a citizen of another state the privileges of being a United States citizen. So if you are a citizen of Nevada and you visit California, California cannot deny you the privileges and immunities of being an American citizen. Now that's a very narrow range of rights under privileges or immunities, because when this was first reviewed in the slaughterhouse cases in the 1870s, the Supreme Court essentially said that the privileges or immunities clause added nothing to either substantive due process or equal protection, and therefore it was essentially subsumed by those two clauses. Then in 1999, the Supreme Court concluded that no, privileges or immunities must mean something. And what it means now is states are not allowed to infringe upon your right to travel and live where you choose to in the United States. And so any kind of residency requirement that prevents you or discouraging you from moving from one state to another state will be a violation of the privileges or immunities clause of the 14th Amendment. And the way it arose was pretty straightforward. California offered one of the highest amount of compensation under welfare. And it passed a law that said if you come to California and you receive welfare and you were a citizen of another state, you must live in California for 1 year before you can get the amount of welfare that California gives, and you were limited to only the amount of welfare you got from your state of origin. The U.S. Supreme Court said you can't do that because that inhibits one's right to live where they choose to in the United States. And so that would be a violation of the privileges or immunities clause of the 14th Amendment. Now, normally when these are tested, the test always has the plaintiff as some kind of corporation. And as I said earlier, corporations have no standing under either Article 4 or the 14th Amendment. And so the analysis was pretty simple. If the corporation were to attack what the state did based upon the privileges or immunities clause of the 14th Amendment or the privileges and immunities clause of Article 4, the corporation would lose because it doesn't apply to them. And that was an easy analysis. But then came the July 2025 bar exam. And on the July 2025 bar exam, they had a question about privileges and immunities and privileges or immunities. And the fact pattern went something like this. Some state offered a scholarship for students to go to medical school in their state. That scholarship was contingent upon a couple of things. Number one, after graduation, you had to remain in the state. Number two, you had to agree to provide medical services in distressed areas or neighborhoods that were short on doctors. And finally, the criteria included you had to be a member of some minority group. And the call of the question was fourfold. Number one, is it a violation of the Equal Protection Clause? Number two, is it a violation of the Due Process Clause? And number 3 and 4, was it a violation of privileges and immunities or privileges or immunities? So let's go through it. First of all, is the state that is passing this law under Article 4, are they denying non-citizens the rights that they afford their own citizens? And the answer there is no. Anybody can apply to this law school, and if you get into that law school, you would be entitled to that scholarship if you agree to whatever the terms are, which is you must remain in the state after medical school and practice in a distressed area. The race issue, that goes to equal protection. It has nothing to do with privileges or immunities, so we don't have to worry about it here. And so here, the state is not preventing out-of-staters from coming and practicing medicine in the state. All they're saying is if you go to medical school here, it's free so long as you meet whatever the criteria is. That is not a violation of privileges and immunities under Article 4, and therefore it would only get the rational basis test because no law can be arbitrary, and it would pass the rational basis test because the government has a legitimate interest in promoting medical services in distressed neighborhoods, and this is rationally related to doing so. So this therefore does not violate Article 4 Privileges and Immunities Clause. What about the Privileges or Immunities Clause of the 14th Amendment? Is this a burden that prevents people from moving from one state to another? Not at all. If you live in Nevada and California is the state that's offering this, you can come to California. You can agree to all of the terms that you will stay in California after you graduate medical school and you will provide medical service to distressed neighborhoods. Therefore, you're not being denied anything that citizens of the other states would enjoy. And so as a result, the privileges or immunities of American citizenship would not be violated. And we would then again have to use the rational basis test to show that this is lawful. So to sum it up, we have two different clauses of the Constitution dealing with concepts of privileges and immunities. Article 4 is privileges and immunities, and it applies to states denying citizens of other states the rights that they afford their own citizens. If the state does that, it has to pass intermediate scrutiny, meaning the law must be substantially related to an important government interest. On the other hand, we have the 14th Amendment privileges or immunities that prevent states from denying the citizens of other states the same rights that all citizens of the United States enjoy. And primarily for our purposes, the use of the 14th Amendment has to do with when one is being denied the right to move into another state, and that's typically going to be through residency requirements in order to get a benefit from that state. That's the difference between privileges and immunities of Article 4 and privileges or immunities of the 14th Amendment. If you found this helpful, you're going to love our course, Personal Bar Prep, the original small group preparation course for the California Bar. Leave a comment or like the video, and hope to see you soon. Thank you so much.